I got nightmares in my head, I fear thoughts build up until I can't hear. That my mind fills up into a creature, and it haunts me somewhere much deeper. I got nightmares in my head, I fear the thoughts build up until I can't hear. That my mind fills up into a creature, and it haunts me somewhere much deeper.
Hey guys, welcome to quite a moment in the annals of true crime. It's not actually that often that we see this sort of thing. The last time it happened was 2018, wasn't it, with the Chris Watts case? And I must say, I often feel irritated when people say, why doesn't he just confess? Because it's so rare, but the fact is it does happen occasionally. And this is one of those occasions. Now, the question is, what sort of confession are we going to get? Are we going to just get guilty, or are we going to get some information? It's an opportunity for Bryan to almost share his manifesto, if you will. It's his last chance to sort of make a statement. So in a way, I think that's quite tempting. On the other hand, as somebody else said here, is he really going to say something like, I hate women, I had a grudge against women because I couldn't get laid, something like that, what Pauline Buckles said? I do think it's a lot more than that. And because it's a lot more than that, it's actually quite difficult to express kind of succinctly. Mark Tweet says he must allocate. Have you guys seen this Facebook post from the family? I'll just put that on screen, where they say, we had so many people reach out to us. We stand strong that it is not over until a plea is accepted. And then they say, at a bare minimum, that's over there, right? At a bare minimum, please require a full confession, full accountability, location of the murder weapon, confirmation the defendant acted alone, and the true facts of what happened that night. We deserve to know when the beginning of the end was. How many of those do you think we're going to get? Do you think we're going to get a full confession? Do you think we're going to get full accountability? Do you think we're going to get location of the murder weapon? Do you think we're going to get confirmation the defendant acted alone? I must say, is there anyone here that thinks the defendant didn't act alone? Anyone? And then the true facts of what happened that night. Do you remember early on, there were a lot of commentators who felt that this was the work of a serial killer? Do you remember that? I remember there was a period where, without exception, literally everyone who was talking about this case said that it's the work of a serial killer. And I was the only person, this is before we found out who it was, I was the only person who said, no way, it's not the work of a serial killer, because it had all the marks of an amateur written all over it. But do you remember that there were quite a few channels saying it's a serial killer and you're going to find bodies in Pennsylvania, right? And, you know, what I find kind of interesting is, do those people, before the fact, those commentators, are they held accountable for those outlandish statements? They even had experts on their channels saying the same thing, you know, and did that turn out to be true? Oh, well, if it wasn't true, it's no big deal. Oh, isn't it? I mean, it should be. It should be a big deal. In the same way he should hold himself accountable, so should we, for what we get right or don't get right. Anyway, let's have a look at what's in the news right now.
We start with the latest on the Bryan Kohberger case. The suspected quadruple murderer will appear in court today to formally accept his plea deal. The family of one of the victims, Kaylee Gonzalez, issuing this new statement saying,
Yes, I've just read that statement out to you, but it is interesting how vocal the Kaylee's family have been, and other family members have been different. Ethan Chapin's family have been very different. They've had a very different, I feel like quite a, what's the right word? They've just had I think quite a, diplomatic is the wrong word. They've just treated this whole situation with grace and with dignity, and it hasn't been they haven't turned it into a media spectacle.
The following quote: "We stand strong that it is not over until a plea is accepted. We will not stop fighting for the life that was stolen unjustly. While we are cognizant that some may have wanted the plea, the prosecution relayed to us."
So there were some rumors that no one wanted this plea deal, but there's a admission that some people did. Some people on the victim's family side did want it, right?
It was not a majority vote that was the deciding factor in offering this plea. The family would go on to say they, quote, require a full confession, full accountability, location of the murder weapon, confirmation the defendant acted alone, and the true facts of what happened that night.
So as we go through the plea deal today, it'll be interesting to find out or to mark off how many of those on the Gonzalez wish list are, how many of those requirements are met? How many do you think are going to be met? Okay, so now we go to GMA. Let's just see what they're saying.
More on the Idaho College murders case after Bryan Kohberger agreed to plead guilty to all counts. Shortly before we learned of the plea deal, Kana Whitworth sat down with the family of one of the victims, Ethan Chapin. I want to go back to Kana in Boise. Good morning, Kana.
Yeah, George, good morning. So the last time that Jim and Stacy Chapin saw their son Ethan alive, it was Parents' Weekend at the University of Idaho. They told me they left full of pride. Their 3 children, their triplets, were living their best lives.
Okay, so I'm going to take you guys to, we've still got about 10, 12 minutes before the proceedings are meant to start. We'll see if they do. But I'm going to take you guys to a video that I made in May 2023. Guess what the title was? Is a plea deal in the offing? It's 2 years ago. And let's just review what was discussed then.
4, murder in the first degree. Yes. Do you understand the count 4, murder in the first degree? Yes. Do you understand the maximum penalty? Yes. Do you understand the charge in count 5, murder in the first degree? Do you understand the maximum penalty? Yes.
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. Bryan Kohberger made at least 2 fairly serious faux pas during his brief 15-minute session. That was his arraignment hearing in court today. The first, as you heard in the clip provided, he actually interrupts the judge as the judge is saying the word murder for count 5. The second faux pas, well, I'm less sure about. I wasn't in court, but it seemed to occur at the end of the session when Bryan wanted to leave the court. I think he was attempting to leave either before the judge had left the court or before the orderlies were ready. But you sort of seem sort of hesitating. It does also look like that his hair's grown slightly, doesn't it? Since we last saw him. They didn't. So what has always been kind of strange about this case was how long it took for Bryan to actually enter a plea on his own behalf. Did anyone notice that like most cases, it's pretty clear what the position is of the defendant. In this case, Bryan didn't seem to want to say anything, and so a plea was entered on his behalf, which in a way makes you wonder whether he was trying to keep his options open in a sense, right? See much interaction between Kohberger and his public defender, Ann Taylor, other than a quick, awkward blink and you'll miss it smile just before he sat down. Also, seemingly no greeting or acknowledgement of Taylor when the session was done and Kohberger got up to leave. It makes one wonder how well the two are getting along. And you notice this when you've been sitting in trial looking at Lori Vallow and how she
how warm she is to attorneys, how she engages with them constantly at the beginning, during the sessions, and at the end of it. And in comparison, you get very little of that from Kohberger. You kind of get the sense that he's quite a cold fish fellow. A lot is going on in his head, and I think it's a mistake to assume that he doesn't feel anything. The thing is, he just locks all of those feelings under the surface. One definitely gets a nervous vibe from him, watching his face and those big, wide, blinking eyes in profile. Personally, I'm surprised that he didn't respond, "Yes, Your Honor," in those numerous times that he says yes, yes, and he does answer his words. When you hear him, he does sound quite assertive. He does sound quite confident. I don't know whether he looks so confident. In the courtrooms I've been in, it's typically decorum for people present to show respect to the court, which is why you stand when the judge enters. And in this case, the judge's name is Judge John Judge. Quite funny. One wonders whether his family name made him think about becoming a judge. Anyway, when the judge enters, you stand. When he leaves, you stand. You don't talk while in court. There's all of that respect. And so the way that Bryan answers, just to me, is quite strange. Just to answer these questions with yes and nothing else, it felt awkward to me.
So I guess what I was trying to get at there, although I don't think I explicitly said it, was that Bryan seemed to be socially awkward. When you're aware of decorum, and when you know your place and know your role in society, whatever situation that is, that is kind of a sign that you socially, I wouldn't say sophisticated, but you're not socially unsophisticated, right? And so if you're in a courtroom situation and you ask questions and you just say yes, I guess some courtrooms are different, but the ones I've been in, you tend to say yes, Your Honor, and it's very differential. I actually recently saw a body cam thing where an officer stopped or pulled over a vehicle, and there was a black judge inside, but he didn't know she was a judge. And the way that he spoke to her, and the way that she spoke to him in a polite way, he spoke to her in a very casual way, and he ended up being suspended. He was a really not a good, I'm not saying all police officers are that way, but he even went as far as breaking this judge's taillight. He didn't know she was a judge. And then went, I'm going to have to cite you for that as well, when he broke it. And I'm just saying that's an example of even a police officer who's not really aware of decorum, just in terms of his role as a police officer. And I kind of got that feeling a little bit with Kohberger, that he's a little, more than a little, socially awkward. And that social awkwardness is not just with regard to ordinary people, it's obviously also with regard to the opposite sex. And I think that's a big part of the problem here, is that he was this 28-year-old in a university situation, still socially awkward, and he couldn't kind of connect to the student fabric. And that started to frustrate him more and more. And then it started to make him more than frustrated. I think he started to feel angry. Right.
I don't know what you think, but, that said, if it was a real issue, you'd imagine his defense lawyer would have or could have advised him otherwise. I heard also that Kohberger made eye contact with court TV reporter Chanley Painter. Not surprising if he did, but it shows, if he did, that he can't keep his eyes off attractive women, not even in a courtroom setting with the cameras streaming. And so in this episode, in this analysis, we want to ask the question, why did Kohberger elect to stay silent rather than enter a plea? It's kind of a legal question in a sense, right? Why elect to stay silent? Before we get to that, if you haven't subscribed to the channel, please do. If you're not already a subscriber, please consider subscribing to this channel. I've been to Moscow. I've sort of gone around the neighborhood. I've gone to his neighborhood. And that definitely, I think, counts for something. I've driven around not only Moscow, but sort of further afield to Pullman and so on. If you're enjoying this episode, please like, share, leave a comment. You can also hit the thanks button, and let's get started. Bear in mind, we'll also be covering the trial on a daily basis when it starts in October. My guess is that Kohberger chose the option he chose in order to do what he's been trying to do all along, try to impress people with the notion that he's smarter than they are. And you get a sense, just in the tone of his voice, that he seems quite confident in, well, like, do you understand this? Yes. Well, do you understand that? Yes. That is almost the way that he seems to feel that he can display his power. But I think there's also another possibility for why he may have remained silent. Kohberger may wish to keep his options open. Bear in mind, if he pleads one way or the other, perhaps he's considering a plea. People have been thinking about that. Perhaps he will settle prior to trial in October. He's got 4 months. And bear in mind, Idaho is a death penalty state. According to USA Today, quote, Idaho has the death penalty, and under a new law passed earlier this year, state officials could seek to have Kohberger executed by either lethal injection or a firing squad if convicted by a jury and sentenced to death. Under state law, prosecutors typically have 60 days from today, right? From right now. Basically, within the next 2 months of the 4 months between now and the trial, to formally notify Kohberger if they plan to seek the death penalty. That's the end of the quoted section. What do you think should happen here? Should they seek the death penalty? Will they seek the death penalty? So perhaps Kohberger will decide how he intends to plea once he knows for certain what the state are going to do, whether or not they will pursue the death.
So what I found really interesting just in how this case sort of played out was the length of time between when the crime is committed and when it actually gets to trial is so stretched out that by the time you get to the trial, even if you've covered this trial religiously like a true crime YouTuber, there's no way you can just stay on it for year upon year upon year. And so by the time it gets to trial, you've forgotten a lot of what's taken place. Part of what is, I wouldn't say being forgotten, but part of what dissipates is your emotions. And so when it swings back into the legal arena, and he says something like, well, you know what, I want to field alternate suspects. You, the public, might be quite okay with that because you haven't really been paying attention. Also, a judge may be kind of okay with that because all the sort of furore surrounding the case is settled. And that's why the defense often play this very long game in introducing evidence and introducing things that they're going to do very, very late, when those emotions have subsided, when amnesia has set in. And so, can you imagine Bryan saying very, very early on that introducing 4 other suspects, how would that have played out? I think there would have been a lot of emotions, but in another way, there was a lot of uncertainty very early on. Maybe a judge would have been receptive. It's just it's an interesting legal strategy either way, isn't it?
Penalty against him. It can be a harder hurdle in a way. It can be a tougher bridge to cross in a sense. Sometimes it's easy to get the verdict, but harder to get the death penalty. You may have one juror holding out, right? Or a juror who in principle doesn't believe in it. If they don't ask for the death penalty, he might take that as a sign of weakness in their case as well. If they do, who knows what's going to happen. I still feel, because Kohberger has this strong sense of proving how smart he is, I think he is going to take his chance in court, as this will be an ideal setting for him to show off, in a sense. We may think murderers or murder suspects don't like the attention, and I don't feel Lori Vallow particularly wanted the attention she got in court. But I have a feeling Kohberger, who's felt like the invisible man for most of his life, will relish being at the center of high-profile proceedings. That's what I wrote in preparation for this, but watching him, he seems, although he sounds confident, he seems nervous and kind of uncomfortable, and he seemed.
All right, so just to let you guys know, it is 1 minute past 11 local time. I am monitoring the live feed. So far, nothing, but as soon as court proceedings start, we will jump onto them. So it should be any minute now.
To be able to not wait to get out of the courtroom. And that was the other faux pas. As I mentioned, he seemed to move towards the door before the orderlies were ready. Small things, but nevertheless makes you see that he seems to be a little nervous. You didn't really see that, I think, once in the Lori Vallow case, not while I was there. So the countdown starts for the trial starting in 4 months in early.
So you may have noticed that I'm referring in this video to the Lori Vallow case. Well, it's because I was in Idaho and I was actually in the same courtroom where this plea deal is going to be heard. I've actually attended trial in that courtroom, and that was where Lori Vallow was on trial. And for a while, I was considering attending this trial, but I've actually changed my mind over the course of covering this trial, and looks like that was the right decision.
Early October. What's going to happen between now and then, we'll see. If the trial does kick off, this channel will be there every step of the way to cover it. Thank you for listening. Oh, by the way, I will be doing a live stream on the Team Peachtree channel.
So you can actually see how my feelings have evolved. At the time that I made this video, which was 2 years ago, I was very much in lockstep. I'm going to be covering this. I'm not going to let this case go. And my feelings changed significantly, where I felt, certainly I thought this case would go to trial a few months later, and instead it dragged on 2 additional years. And during that process, I thought this is just totally unfair to the student community, and I don't want to participate in that. And also, there's a gag order, right? There's a gag order, and there's a gag order for a reason. Just see, we still got this appearing on screen, so the court will start, I guess, quite soon. At the moment, it's a little bit late, but it should be any moment. I just want to quickly go to
I want to bring now, though, and we're joined exclusively by her, renowned forensic psychologist, Dr. Catherine Ramsland. As you may know, she was Bryan Kohberger's professor and advisor at DeSales University in Pennsylvania. She has not spoken publicly about Bryan Kohberger until now. She's been on this show.
So she's basically breaking her silence on Kohberger, and quite a few people actually have been, in terms of this latest legal development.
Talking about other cases, but she's been very, very careful not to talk about Kohberger because of the trial, because she was going to be a witness at the trial, and she now feels comfortable to open up to us. And we've got so many questions, Dr. Ramsland. I've got so many questions I've wanted to ask you for so long. I want to start with, how did you first meet Bryan Kohberger? What classes of yours was he in?
Okay, I want to be just clear that I'm still within the FERPA limitations that protect students and student information. So I will talk within that.
Just also bear in mind, the plea deal hasn't technically been accepted. It's going to be accepted.
I met him in the fall of 2018 when he came to DeSales University. He had an associate's degree, and he was going to get into our 4-year program as a psychology major. He selected the forensic track, which made him an advisee for me because I managed the forensic track. And he was also in my class that semester.
So it kind of is very ironic, this case, where you have a law student, a little bit like, not quite law, criminology, I guess, which is slightly different, similar to Ted Bundy. And of course, in this case, he committed his first crime, made a mess, and now he seems to be admitting to it. It's not quite the storybook criminal mastermind or the criminal legacy, I think, that he thought he would have.
And Dr. Elmondson talks about FERPA. I should have mentioned that there's a law, it's a federal law, I believe, that she is not allowed to talk about certain aspects of a student, their grades, certain parts of their academic life. It's almost like a HIPAA. So
basically, all the stuff that we'd want to know is what were his grades like, what kind of student was he. Although we do know about his high school to some extent. We know that he had visual snow, and we know that he was addicted to heroin. We know he was very overweight at school. He had a fascination with the military. I think he wanted to be a ranger at a certain point. You guys remember all of that?
She's going to tell us what she can, but unless Bryan Kohberger signs off, she's legally not allowed to talk about certain elements of his academic career. So just keep that in mind if there's some things that Dr. Ramsland can't answer. What was your perception of him?
He seemed like eager to be in the classroom. He was polite. He was respectful, intense, and curious. And there was no reason for me to think that he was anything other than someone who was really interested.
So now, if I was asking a question, I would want to know what were his relationships with his classmates like, and what did they think of him? You know, what did his peers think of him?
In this potential career.
Was there anything looking back now that was strange about him or that you noticed?
When I look back, there really isn't anything.
And I must say that to me is, I don't know, ironic. You've got someone who teaches, isn't it, criminal psychology? And she, even though she knows in hindsight what the situation is, she doesn't seem to be able to offer anything of value. The only thing she's said so far is that he's intense. Wow, you can't think of anything, and you had this extended exposure to him. It's a little, more than a little disappointing, isn't it?
That stood out to me. I think when you're a teacher, your instinct is to accept students at face value. You don't, start with suspicions or, and there really weren't any red flags. He was always really quite respectful. And
so if you listen to that, she almost sounds like a defense expert saying, there were really no red flags. He seemed like a nice guy. This is even in hindsight when he's about to make a plea deal, accepting that he murdered 4 people. So I must say I don't know her very well. As far as I know, she's written a book, hasn't she? And to say in hindsight, even though I had this extended exposure to someone who became a quadruple murderer, I saw 0 red flags, really not a single red flag. Is that because there weren't any red flags or because you failed to see them? And that kind of makes you wonder, can you have an academic knowledge of crime and criminals, right? And then when it is tested in a practical way with a real person within a real scenario, how good is that academic knowledge then? And I do think it's important to ask that question. I don't think you just go, wow, I didn't see any red flags. Is that all right that you didn't see any red flags? You had a quadruple murderer that was, he was still, that criminal psychology was still germinating. You didn't ever see him get really angry or snap at someone. You don't remember a single instance where something strange happened. Was he social? Was he just like all the other kids? Did you not notice anything? This is not like someone who just didn't know someone. Teachers often have more exposure to students than their own parents. and then you still don't notice anything. It's just for me a little bit curious.
Grateful. He would thank me for things. He was attentive. He would do the work. I didn't have any concerns.
What I think it was 4 classes that you taught him in. What were those classes?
So, I mean, I'm not saying this, she's saying this. She's saying, I didn't have any concern. So, if you actually called her as a witness, what is she going, I mean, she would be a great defense witness because she's going to say nothing. She's going to say, it seemed completely normal. There were no red flags. Well, okay, so I guess that means he didn't commit this crime. It would be interesting, was she listed as a prosecution witness or a defense witness? And I think one aspect that might come into play in terms of the prosecution side is, didn't he write an essay about something, or wasn't he interested in particular crimes? Wasn't he interested in certain crimes that, I mean, surely that shows where his psychology is. If he's interested in serial killers or serial killers who stab people or something like that. I remember I once went on a date and we had a really good, we watched a movie, I think it was Invictus. We had a really good dinner. And then at some point, I think she asked me a question. I started talking about serial killers and I just didn't stop. And then I think she got kind of freaked out, right? And that's kind of understandable. But by the same token, this teacher, didn't she have the same kind of thing? Like, wow, you're really, really interested in these macabre cases. And I'm going to say, I'm not particularly interested in serial killers. Rex Human, yes, but generally not really. And so did she not notice something like that? A sort of an obsessive interest in particularly grisly crimes, in violence, right?
There were 3 undergraduate courses in the forensic track that I taught, and he was in all of them. Well, one was Introduction to Forensic Psychology. Another was my death investigation class, which was called...
So there you have it. I think she's the author of The Serial Killer's Apprentice. And, for someone to have written a book about, I don't know, I haven't read the book, but is it about identifying the traits of a murderer and criminal psychology? Well, did you succeed in terms of this particular real life example who came into your orbit, right? And it's a important question to ask. I'm not trying to criticize this lady, and I'm not trying to do anything like that. But you really want to ask those questions of yourself. Do you think you could have recognized someone like that? And I think court is starting. I think the court is starting. Wow, so it's just starting to get interesting. There we go. It is. That's also true. That's also true. University classes are also different to school classes, right?
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms. Allen is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case.
Decorum.
I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement.
It's actually amazing that this is starting off with the public, basically the true crime community, being chastised for, I guess, trying to manipulate him, trying to influence him, trying to bully him. It's quite extraordinary.
I ask that you not continue to mount such campaigns or to send me information like this, because, again, it is not appropriate and, frankly, not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families.
So just FYI, can you see where my cursor is? That's Bryan Kohberger sitting over there, right?
The families of the defendant for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have.
I'm just going to change live feeds to this one.
Questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires
10,000 jurors
prior to the beginning of the voir dire process.
Pretty expensive.
And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified.
You know, what is very hard to avoid is it's almost like a crime has three dimensions. It's the dimension of the crime itself. In other words, in this case, 4 people die. So that's the one dimension. It's a very direct thing. 4 people lose their lives. Then there's the dimension of the cost to prosecute the trial, which the state bears, right? And in this case, it's enormous cost. And then there's a third dimension, which is the rippling effects which sort of go into society, where people become afraid and they suspect one another and the conspiracy theories and all of that. And all I'm saying is you have a crime, one incident, but it has this ripple effect where it costs society and it causes tears in the fabric of society, which can be very, very damaging. And we've got to be careful not to aggravate the original crime. And that is where I think a plea deal is such a good thing, is it brings all of this to a close, the costs of it, the time that it's taking, and the pain, it sort of allows the moment of healing to be advanced, right?
And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason.
So I just want to respond to where Aaron says, I want to hear him say that he did it. I think it's going to be something like the prosecutor saying, did you murder Ethan Chapin? And then he would answer yes. Did you murder Xana Kernodle? Answer yes. I don't think it's going to be a confessional the way that you're expecting it to be. It'll be more of a question and answer. We'll see.
Reason you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well.
If you look at Bryan, he's rock solid. He doesn't seem to, he's just looking at the judge. He doesn't seem to be looking at anyone else. You can imagine, in a way, he's got the weight of that entire courtroom bearing down on him. He's about to say the thing that most criminals are loath to say, which is, yes, I did murder this person and this person and this person and that person. Something Laurie Vella could never do. And he does seem almost frozen the way that he's sitting there, immobile. He probably is quite nervous.
All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
He's thin, eh?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone?
So this is the stuff the conspiracy theorists need to pay attention to. You know, did anyone force you to agree to this? So when he says no, does he mean yes? Because you can bet your bottom dollar there are people that are going to try and spin this, that someone is putting a gun to his head in some way, and he doesn't have a choice in this matter. I must say, when you look at his attorney, she doesn't look resigned or defeated. She seems almost chipper, which I'm kind of surprised at. Can you imagine if you, a defense lawyer, and your job is to defend a client, and isn't part of that job that you believe that they're innocent, only for them to turn around and say, you know what, I actually did kill 4 people. Shouldn't you be surprised? Shouldn't you? It's not actually funny. Shouldn't you be shocked? Shouldn't you be like, wow, I shouldn't have taken on this case. I didn't know you are guilty after all. Or do you actually have lawyers defending clients that they suspect are guilty? That's the other side of that coin.
Other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
It would be nice if he could ask, just informally even, why are you taking this plea agreement? You know, well, so that I don't face the firing squad.
Are you pleading guilty because you are guilty?
Yes.
There we have it.
And counsel, obviously there have been a number of motions filed to support.
Remember I said, I don't think he's going to sort of make, I think someone called it an allocution. I don't think he's going to make a speech, she might volunteer to do that. But a lot of this so far has just been yes, yes, no, no, right? We'll see if he does elect to make a statement. Do you think he is at this point?
Press evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12 filed? Are there any other than the plea agreement that I would be lenient or easy? The right to serve on jury duty, the right to hold public office, and the right to vote. First in the form of a civil judgment to operate. And again, you may be required to pay restitution to the victims of the right to serve on jury duty. The plea agreement that I talked about today, do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of
It's quite surprising.
motions
No
filed, to
response,
suppress
no
evidence
reaction,
in
really,
this
even from
case.
his lawyer.
Other than
No.
those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your
Yeah.
sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
No, that's an important one. Are you satisfied that your attorney has done all they can? You can't complain later on that you were misinformed or given the wrong advice, right?
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers
Does it look like he's saying yes but shaking his head no?
truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
In a way, it does seem like what's being arranged here is almost like a rental agreement. It just doesn't seem like there's the right emotion from him. I mean, literally what he's admitting is killing for people and giving up on his own story and allowing the state to lock him up and throw away the key for his entire life. And he's just very matter of fact about it, isn't he? I mean, if it was you, God forbid, but if it was you and you were saying you did something for whatever reason, would you be unemotional about admitting something that was going to cost you your freedom for the rest of your life?
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you.
If you think about it, at any point here, you could say no to any of these things, and then I mean, it's a lot of questions the judge is asking him. At any point, you could say, you know what, I don't know if I have gotten such good advice from my lawyer. On the other hand, I don't know if this is in my best interest. There's so many areas where you could say, wow, maybe this is a mistake.
To understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right.
Okay, so here's a really interesting comment. He's not autistic, in my opinion. Alyssa says shows no remorse, but that was going to be part of his defense. You know, I think they're going to say, you know, he can't sleep at night. He does go for drives at night, and maybe he went driving out that night and someone else did something, and they were putting this on him. If he can't remember where he was or he's awkward with people, it's because of his autism. That was going to be his defense. Here, he's certainly saying there's nothing preventing me from making a educated, intelligent decision regarding this issue. In other words, I'm capable, I've got the capacity to do that. Part of his defense, if he'd taken it that way, probably would have been to say he's autistic. Now he's literally saying, no, I do have capacity to make this decision. I'm not saying he doesn't have autism. I'm saying I don't think the autism is at such a level that it is mitigating, right? Do you?
So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence, Loca County, Idaho, you 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully.
You know, in the way that the judge is narrating this, I wouldn't be surprised if at the mention of each person's name, there's a little bit of a flash, like a very visceral flash of their last moments in his mind.
Unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Remember that selfie that he took on the night of the incident or the next morning of the incident?
let
It's
me
a
ask
bit of a
you, did
different
you,
Kohberger to this
on
one,
November
right?
13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022
I can't prove it,
and
but he
November
likely
7th,
was, right?
the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. on the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching
Not sure where that audio echo is coming from.
the description of the defendant's Hyundai Elantra, entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that
Not the front door.
would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel, still awake at this time, in fact, had taken a DoorDash order not long before this started. Her room was not on the third floor, it was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is.
You say holding a container?
At approximately 4:20 that morning, so this would have been 15 minutes or so later, Finn's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town.
Must be weird for Kohberger having this experience that he would think only he knew about being read out moment by moment, and then reliving it probably in his mind, right?
The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time.
I remember thinking when it was asserted that he didn't take a direct route back, that was really, really suspicious. You know, if he'd gone there for whatever reason and just driven straight back, he could say, you know, I went to do whatever, I went to buy something. But the fact that he would purposefully drive this roundabout route was in itself very incriminating.
So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning.
Basically tracked him from the one end to the other.
Later that morning,
even though he tried to not be tracked.
The 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence.
Well, if I can speculate, I think a possible reason why he returned was he realized, oh my God, I don't have the knife sheath, and maybe he was worried that he may have dropped it and maybe he could just pick it up. Maybe he thought it was lying around outside and he was trying to retrieve it. That would certainly make sense, right?
About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment.
That's that one.
With a thumbs up.
With a thumbs up. Mission accomplished.
The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 2, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you.
Well, he seems to have gotten quite emotional towards the end. It was the only emotion we've seen so far.
All right, based on the state's proffer, and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right.
Did you notice he sort of
Find
did
that
this?
the defendant understands the nature of the charges, and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available.
So
We
it
want
seems
to,
like you'll
though,
be
make
sentenced
sure that
now.
all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And
Uh,
certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. We
It'll be a
obviously we have
separate-
numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We tell the victims' families that we're looking.
We start with the latest on the
All right,
Bryan
so
Kohberger.
because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th.
Okay,
We'll start at 9 in the
23rd.
morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing.
So when we see him
Anything else,
again, he'll
Jimmy?
be wearing jail
No, Your Honor.
garb,
Thank you.
prison
And
garb.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Okay. Well, that's it. Remember what I predicted? I said he's likely not to make a statement. He'll just answer yes, no. And yeah, I must say it's pretty standard plea deal scenario going on there. We will get, I think a more detailed picture on July 23rd. We'll hear from the family members. We might hear from Bryan then. But there you have it. One thing I was surprised in a way not to hear about, I've called it bad Teachergate. I don't know of any other channels that covered this aspect, but it was basically Bryan Kohberger was not very popular with his classmates at the college. Remember, we were talking about the professor who didn't see any red flags. Well, his own classmates saw red flags. He made derogatory statements to women, and I think there was a homosexual student. He also made slurs towards her, and even his class that he taught, he wasn't very popular, and there was, I think, a huge group of them protested about what he was doing. I referred to it, if you remember, as bad Teachergate, and I was wondering whether this might come up as part of the fabric to this case, and I wouldn't be surprised if it would be precluded as a result of it being bad character evidence, which the court tends to be quite strict about, hearsay, that sort of thing. So nevertheless, I do think it was very important and very material to his story. He not only felt spurned by his own classmates. Remember, he was also studying, but he was also a teacher, and his own class didn't really like him very much, and they felt he was very, very strict. And I think that strictness is also a sign of someone who's, they may look normal, but they are literally kind of out of touch with their fellow man and woman, right? B says allocution is defendant's right and is for purposes of mitigation sentence. Yeah. The processes in different states are different. Sometimes you have sentencing that happens the same day. I remember that happened in Texas, and I remember I left court early thinking, well, the sentencing is going to happen some other day, and happen the same day. So it does differ from state to state. Debbie says, I used to teach at university. I was very perceptive, counseling psychology. So have a look at some of your questions. James Patterson books comes out July 14th, and the documentary July 11th. It's a pleasure, Amy. I'm going to get on my treadmill, get a little bit of exercise. I have been sitting a lot and developed some really chronic backaches. I need to get out my chair quite soon. Pauline says perhaps the victims' families will be allowed to speak. Yeah, no, they definitely will be. They definitely will be. You'll probably have each of them being allowed really as much time as they want. So, all right. I'm not going to take it further than that, guys. Thanks a lot for joining me, and I'll see you guys next time. Ciao.